Thank you so much for joining us today. It's what can I say? It's an interesting time, and I know there's a lot going on. That's an understatement. So really appreciate your coming with us and talking about some very important issues, although not necessarily the vote count in Philadelphia. I'm so excited to introduce our speaker, Asha Behondri. She is the senior staff attorney for the In Speech, Privacy and Technology Project of the American Civil Liberties Union, where she works on litigation and advocacy to protect freedom of expression and privacy rights during the digital age. She also focuses on the impact of big data and artificial intelligence on civil liberties. She's litigated cases, including Sandvig versus Barr, a First Amendment challenge to the Computer Fraud and Abuse Act on behalf of researchers, and Alasaad versus Wolf, a challenge to suspicion, I can't even say anything today, I'm so overtired, for reasons you all know, suspicionless electronic device searches at the US border. She was previously an Equal Justice Works Fellow with the ACLU Immigration Rights Project, where she was involved in litigating cases concerning right to counsel in immigration proceedings and immigration detainer policies. Asha is a graduate of McGill University, where she was a Lorraine Scholar, and she received the Allen Oliver Gold Medal in Political Science. The Columbia University Graduate School of Journalism, and she's also a graduate of Columbia Law School. She was a law clerk for the Honorable Amelia Kearse of the U.S. Court of Appeals for the Second Circuit. And I have to say, it was my great pleasure to do some work with her early in the pandemic on a bunch of pandemic-related issues. And I suspect our paths will keep crossing because this pandemic has not gone away. So I'm thrilled she's going to talk to us about civil rights during a pandemic, privacy, protest, and racial justice. She'll talk for about 45 minutes. And then we will open it up to Q&A. So please join me in welcoming Asha to our virtual fall lecture.
Thank you so much for that introduction, Wendy. Thank you all for joining, and it's my pleasure to speak today. I know it's been a really intense and busy week, so I'm very happy to be able to speak to you all. My goal today is not to speak as an academic, but from the perspective of a civil liberties and civil rights lawyer about the challenges that we've seen during this particular pandemic, but also about the challenges of civil rights and civil liberties in a public health crisis writ large. First of all, I just want to acknowledge the situation that we are in. There's over 120,000 cases, or over 100,000 cases at least daily for the last few days in the United States. Cases are on the rise worldwide. Many people have suffered a lot from COVID-19, including losing loved ones, having long-term illnesses and after effects, and also suffering the economic effects of the pandemic. So I feel like we're in a very sober place right now, and maybe a worse place than we might have thought we'd be this summer. I also, think, as an ACLU lawyer working at an organization committed to civil liberties and civil rights, that public health goals can be advanced consistent with individual rights and liberties. We all know that we're all called on right now to make extraordinary sacrifices for the community good. I think that, as a civil liberties organization, we recognize that. And we also recognize that ordinary liberties and freedoms have been curtailed in some ways, and for good reason. Again, we're called on to make sacrifices for the community and for other people, including protecting our own health. At the same time, as we recognize that we're called on to, change our behaviors in certain ways, that certain liberties may be restricted, it is necessary that we always bring a rights framework to government measures. And I think it's actually necessary for a human rights or a civil rights and civil liberties framework to go hand in hand with public health crises like this, because it's the only way to have any sustainable long-term compliance and trust in public health measures. So, my goal with this is to hopefully convince everyone that a rights-respecting pandemic response is critical, and that we don't have to sacrifice effectiveness of response, as a trade-off with individual rights. So I'm going to focus on three broad areas today. These are areas that the ACLU has been working on since the outset of the pandemic. One, freedom of movement and assembly issues. Two, privacy and technology issues. And three, racial justice and equity issues. But there are a lot of other issues that the pandemic has brought up, including disability rights issues and many more. And so there's a lot of work. In fact, one of the things that has been surprising about this pandemic, I think, for those of us at the ACLU, is that it has touched on almost every issue area we work on, from mass incarceration to immigrants' rights to national security. The list goes on. There's really almost no part of the organization that hasn't been touched by the COVID-19 pandemic. Before I jump into the first topic, which is talking about movement restrictions and freedom of assembly, I want to talk a little bit about the overarching legal framework under which most of the COVID-19 pandemic response has proceeded, and what the implications are for civil liberties. So this is a context where public health powers or emergency powers are often invoked. And usually at the state level, and I think as we've all seen in the United States, at least, the pandemic response has been very state driven. It's been very decentralized, often city level, county level, municipal level, and state level. So what does this mean when I say that emergency powers have been invoked? In many states, you have governors acting under authority, either provisions of law, where the legislature has delegated broad authority for the governor to act, to impose new restrictions, to maybe create new, civil or criminal prohibitions, to take actions that the executive normally could not do without legislative, without legislative approval and authority. As an organization, the ACLU has always been very cautious about uses of emergency powers. There's a long history in this country of emergency powers being invoked. They are rarely taken back once they're invoked. I think on a federal level, we've seen many federal emergencies declared that are never undeclared. So you can sort of end up having this period of perpetual emergency. And the real concern is also that you delegate democratic and legislative power to an executive, which is usually one individual, and there's so much there's so much discretion given that we can have democratic accountability issues. So throughout this pandemic, whenever we've been thinking about what is the state framework involved, we've always said that if there is the use of emergency powers by the executive, which in many of these contexts has happened, and governors have had to maneuver quickly, those emergency powers must be limited. They must be specific. They must allow for democratic oversight so that the legislative branch and the judicial branches, if necessary, still have a role to play. And there must be a sunset period. And I think that's also really important. So if a legislature were to draft an emergency public health law today, I think those would be the requirements that we as the ACLU would say are really necessary. And I think the sunset period is critical. And obviously, nobody can say when is the COVID-19 pandemic going to be over, but you can put in laws, certain criteria, right? If these criteria are met for a public health crisis, whether it's transmission, number of cases, what have you, there are ways to make it more concrete so that emergency powers don't just continue on indefinitely. And, we wake up one day and it turns out that the pandemic has been long finished, but governors in a lot of states continue to exercise a lot of authority that really should be legislative. So I'll move to my first topic, which is the freedom of movement and assembly rights that we normally, I think, take for granted, which have been curtailed in this pandemic. And what is the civil rights framework, and how should we evaluate this? So first of all, I want to just define what I'm talking about. I'm not talking right now about formal quarantines, which are a traditional public health tool. Public health officials can, formally issue quarantine orders or isolation orders and require people to comply with those. I'll talk about those next. But first, I want to just talk about movement restrictions and assembly restrictions, because that's more in line with what we've seen with COVID-19. This has actually been, a pandemic where formal quarantine orders have been rare, and they've been a less prominent part of the response to COVID-19. And I think that must be just because of the sheer numbers of cases. This isn't a situation, for example, with the Ebola outbreak of 2014, 2015, where you had isolated cases, you were using the formal quarantine or isolation powers to restrict those people to try to prevent community transmission, community spread. So here, the real public health tool has been sort of a gradation of movement restrictions, lockdown, shelter-in-place orders, whatever you want to call them. And I think overall, we've seen a variety of these kinds of restrictions, right? They've varied from certain types of businesses are required to be closed, you can't operate at all, to, you can have businesses open, but only with certain precautions taken, to limitations on the types of assemblies, such as whether you can have indoor assemblies or outdoor assemblies, the number of people that can gather, and what requirements you have to follow if you will gather. So, these are obviously limitations that do affect fundamental constitutional rights in the United States, which include the right to assemble, the right to protest, and the right to worship. There's no doubt about it. As critical as these limitations and measures have been to fight the public health response, they do affect these fundamental rights. And so the framework that we've adopted, or the way that we've thought about it at the ACLU and spoken about it, is that while government officials may temporarily limit gatherings, because of the imperative public health needs, including large assemblies, including indoor assemblies, there are a few requirements that have to be met. One, the science has to support the restriction. I think with the COVID-19 pandemic, the science has evolved. And as the science evolves, then we would expect restrictions and limitations to evolve as well. Second, the measures must be continually reevaluated in light of evolving conditions. So it's not enough to set in place a movement restriction, say, no in-person gatherings over 5 people, and then just sort of let it go and never revisit it again. Because when we're operating in a world of fundamental freedoms, the government needs to have the most compelling of interests to justify them. And they've got to be narrowly tailored limitations that satisfy that strict scrutiny standard that we would argue applies. Again, we're not saying that the government could never meet those requirements. It's just that, you have to look at the conditions, you have to look at the scientific consensus, you have to look at, the particular threats in the situation. So continually reevaluating is very important, because, every day, every week, every month of additional restrictions are infringements on people's liberty, and they may continue to be justified, but, public officials owe it to, to the community to make sure that they're not sort of setting it and forgetting it. And then there's another critical requirement, which is that any assembly bans, public assembly bans or gathering restrictions, can't be imposed or implemented in a manner that discriminates against individuals on the basis of protected characteristics or viewpoints. These are 2 principles from the US Constitution: the prohibition on viewpoint discrimination coming from the First Amendment, and the prohibition on discrimination from the Equal Protection Clause. I'll talk about the viewpoint discrimination with a concrete example. In New York State, at some point in May, when conditions were changing, the governor decided that he was going to change the assembly limitations, and specifically allowed certain in-person gatherings to take place over Memorial Day weekend for patriotic purposes. The idea being people can gather, have some barbecues, celebrate the holiday, the long weekend, with certain precautions taken. So, masks if within 6 feet, certain requirements, but not an outright prohibition on gathering in groups of 10, for example. And the New York Civil Liberties Union filed a lawsuit saying that if the governor was going to allow assembly for the purpose of patriotic gatherings for Memorial Day, the state also had to allow it for other purposes. and specifically protest. And we know that May was a time of intense protest in the United States, racial justice protests. There were also anti-lockdown protests. And the key viewpoint discrimination point there was just that if it is safe enough, if the state is determined it is safe enough for certain gatherings with certain precautions and limitations, it doesn't get to pick and choose the reasons, the viewpoints that can be expressed. You don't get to have a patriotic gathering only, but not a gathering that is maybe protesting the government or, has some other message. Let's say it's a gathering for religious worship. So the state eventually dropped that limitation. The case didn't have to be adjudicated, but that's just an example I give of, how we want to be, we've been on the lookout to make sure that these assembly restrictions have not been viewpoint based. And I think for the most part, they haven't been. We've seen in most states that in fact, the gatherings are viewpoint neutral, the gathering limitation. So it'll be a restriction on gatherings beyond a certain number of people, or maybe in certain locations, and that's really important. So, the other point I want to make about evolving evidence, I think, is our understanding of this particular pandemic has evolved. Early in the pandemic, it was unclear whether distancing indoors with or without masking might be enough. Now it seems as if, with further evidence of airborne transmission, that indoors activities may just be more risky, full stop, versus, we now have a bit more evidence that outdoor activities seem to be less risky, even when they involve gatherings, so long as people are wearing masks when they're near each other. And this is fine. I think the fact that, early in the pandemic, officials were operating with a certain set of assumptions or evidence, and later in the pandemic, we might have different evidence and change those restrictions. That's the system working how it should be. It's not evidence necessarily that, things were done wrong. You have to always make sure that these measures are compelling and justified in light of the evidence and conditions in place at the time. That's really the critical point. So, and I also want to mention worship, because I think worship, the right to worship sort of came in for special attention, and many cases were filed over the right to worship more so than the right to protest. And in part, I think this was because a lot of states took the approach of defining essential businesses and did not define religious houses of worship as essential, or in some cases, their movement restrictions and assembly restrictions had the effect of prohibiting religious worship, but allowing people to continue grocery shopping and so forth. Many cases were filed on this. Most of the cases, did not end up suggesting that you have some sort of special right to not follow the general COVID restrictions if you intend to engage in worship. Some of the cases did hold that. A lot of the cases turned on sort of what people were asking for. In some cases, people were saying, look, the right to worship is an essential activity. It's protected by the Constitution. It's as essential as anything else. We'd like to just be able to do it, through drive-through services, or maybe outdoor services, or maybe with certain restrictions indoors. So, for whatever reason, we tended to see more worship cases. And I think in part, it might've been just because worship tends to take place indoors, and those activities were more restricted by states, whereas protest cases, were less likely to come up because most protests that we saw over the summer, racial justice protests, anti-lockdown protests, and others, were outdoors. And while there were at various times limitations on gathering that applied outdoors, it seemed like most states were less interested in enforcing those. And then, in many cases, as long as people were wearing masks, they were even permitted. So many of the issues that we saw with protests were actually curfew issues and others that were imposed not using COVID-19 explicitly as a justification, which we were, I think, surprised by a little bit at the ACLU. We thought that the COVID-19 public health orders might be used more as a pretext just to shut down protests. But with the exception of a few cases, for the most part, the restrictions imposed on protests were just classic restrictions imposed on protests and were challenged on First Amendment grounds, just as impermissible restrictions. I'll turn now to talk about formal quarantine, which I mentioned at the outset is, a category of public health authority that I think has been rarely invoked in the pandemic, but it is essentially the authority to issue an order requiring someone to, be detained, essentially. Usually it's at home, so you could say it's like house arrest, but you are essentially placed into state custody for a certain period of time. You're not allowed to leave, and technically quarantine would cover those who are exposed to a disease and at risk of transmitting it, versus isolation, which would be people who are actively, have a communicable disease that they could spread to someone. We again have a framework at the ACLU that we would argue should apply to evaluating all such quarantine orders. And I think maybe I showed my perspective by saying it's essentially state custody. And when the state takes you into custody, regardless of whether the custody is at your own home, there are certain obligations and requirements that come in, because this is, the highest level of liberty interest at stake. You have no liberty at all for a period of quarantine or isolation. So what are the civil liberties concerns? One,
I'm already muted.
Substantive due process. Under the Constitution, you have to meet this requirement that, for this fundamental liberty interest to be restricted, that you've satisfied this standard. And we would argue that it's a strict scrutiny test, as I said before, for liberty restrictions. And when it comes to a pandemic, I think whether you can justify quarantine really depends on the specifics of the disease. So with Ebola, which Wendy mentioned, we've worked on the COVID-19 pandemic, but we actually first met when we were working on the Ebola response in the United States. And many states got it wrong because with Ebola, there was no scientific justification for quarantining asymptomatic people, because asymptomatic people, even if they had been exposed potentially, could not transmit Ebola. So the lesser restrictive alternative is active monitoring, where people can monitor their symptoms. As soon as they become symptomatic, they can self-isolate. But nonetheless, because of fear and I think a lot of political pressures, there were people who were subject to quarantine orders for Ebola when they were asymptomatic, which we argued were unjustified. They didn't meet the constitutional standard for depriving them of liberty. COVID-19 is obviously a very different case, and with asymptomatic transmission, you can't use that same standard to evaluate whether you can quarantine someone who is asymptomatic. But nonetheless, you'd have to meet that requirement that there's a compelling justification that this person has been exposed sufficiently that they're at risk of transmitting to others. The second category of constitutional considerations is procedural due process. It is really important that people have notice of the restrictions and be given the opportunity to contest them. That's a very fundamental, aspect of the American constitutional system, that you have procedural due process before you're deprived of liberty. And, again, in a quarantine case, depending on how urgent it is, it may be that a state can quarantine someone first and then allow them to challenge that after, but it would have to be very soon after. It may be that you don't have time to give someone the opportunity to contest a quarantine before they go into quarantine, just because of the nature of communicable diseases, but you also can't have someone placed into quarantine for days or weeks on end, having had no opportunity to challenge it. And that's really important because, mistakes can be made. And if someone says, you got the wrong person, but I'm trapped at home and no one's listening to me, that's a problem. If the state got the facts wrong, right? There's all kinds of reasons that you'd want to provide people with that procedural due process. A third principle is equity. This is making sure that people have access to food and the necessities of life, medication, basic hygiene supplies. This one is important. It's also the one that I think is least satisfied by any public health authority in the United States. I think it's the one that people don't consider, and it falls by the wayside. But it's important because, as I said, when you're under formal quarantine order, you are in state custody. The state has essentially taken on responsibility for you, just as if it had placed you in a detention facility, and you'd have all the rights then to food and the necessities of life and conditions that could support you. I think what's happened often with quarantines, and particularly in COVID-19, because so many people have potentially been self-isolating at home at once, is this assumption that everyone can take care of themselves. They're at home, it's fine. But I'll give one example that came to us at the ACLU involving a state that was imposing a quarantine, broad quarantines on anyone coming from out of state. You drive out of state, you come back in. And there was one instance of someone who's driving out of state and coming back in for medical treatment, and this was happening regularly. And having to quarantine for 2 weeks every time you come back from a medical appointment, which may happen with some frequency, was a real human burden. And in particular, if you're not someone comfortable ordering food regularly, or maybe you live in a rural area that doesn't have food delivery, maybe you can't afford food delivery. Being told you can't go to the grocery store for 2 weeks, you cannot step foot outside your house for 2 weeks, but nobody from the state's going to make sure that you have food. That is a real problem. And I think that state did eventually try to set up a system of grocery delivery. I'm not sure how successful it was, but as I said, I think this often falls by the wayside, but it's a really critical point. There are real human costs when people are required to stay home, not work, not take care of their needs. And it's really important that public health officials take that into account. And then the last principle is a stigma principle, which is the state has to take care that it doesn't stigmatize those who are under quarantine or isolation, in particular because when we're talking about a communicable disease, there is so much potential harm, reputational harm, lost relationships, lost business. So privacy of individuals has to be really respected. In the Ebola quarantine context, when Ebola, the Ebola outbreak was going on, we saw, at least in one case in the United States where, law enforcement officers were stationed outside the home of a family that was required to quarantine. And that has a stigma, that has a real stigma, particularly in a community where people know exactly what's going on. So our position would be that, short of some reason to suspect that people are not complying with quarantine, you should presume compliance. You don't need to and should not, put signs on doors, send officers posted outside, all of these things, because that imposes costs on people. In the COVID-19 pandemic, we saw many states try to, come up with a program whereby first responders in the state or in the region would get a list of everyone who had an active COVID-19 infection. And the ACLU state affiliates, in many of those instances opposed that, both from a civil liberties and a public health perspective. We worked with public health experts who said, this isn't actually an effective way to deal with COVID-19 because given the rate of community spread, first responders should assume that every home they go to potentially has someone infectious and they should take universal precautions. And simply having a list of people with active COVID-19 infection might in fact result in the opposite, which is lull you into sense of security in other homes. And so when you weigh this lack of efficacy or real benefit against the real privacy harms of people knowing that if they get tested, the local police department is going to know that they have COVID-19, that's something that we didn't feel was justified. So moving on to the next category of things I wanted to talk about is the privacy and technology element. And many other countries have dealt with this pandemic with a much more technological focused approach. I think, we've heard of some countries where there's mandatory ankle bracelets or GPS monitoring for people in quarantine, use of facial recognition to track people as they, travel around in public, use of location tracking and mandatory use of apps. There's a lot of different approaches that have been taken. And, at the ACLU, probably with, it's no surprise that we have been very skeptical about the use of a wide-ranging surveillance infrastructure to address the pandemic. And there are a few reasons for that. One, we haven't really seen any evidence that technology is a panacea. and that it is a replacement for traditional public health measures like contact tracing and testing, support for people to isolate, making sure there's adequate PPE for people who work in congregate settings or essential businesses. There's a whole host of tools that are available to public health officials before jumping immediately to technology, and technology is not a panacea. But the second, the second concern we have, of course, is that once you build a surveillance infrastructure, it is very hard to undo. And history shows us that, usually when a new surveillance technology is introduced, there is expanded use from its original contemplated one, and then there's abuse. And these things are very rarely rolled back. So, we have put out a series of white papers which evaluated various location tracking or app-based contact tracing proposals. And, for the most part, a lot of them have really not been useful or helpful. I think if you look at some of the actual proposals, they wouldn't, in fact, do much to stop spread. They were, poorly conceived. But nonetheless, we have outlined that if some sort of, automated or technological solution is going to be used, certain, fail-safe privacy principles have to be built into them, including, complete anonymity, making sure that people are not identifiable and are not tracked, that their location is not tracked. And this is a big one, because if people feel that, in order to contribute to helping the public health effort, they will be, essentially their every movement will be recorded and stored and shared with a government official. That's going to have a real chilling effect on people's freedom of assembly, their freedom of movement, knowing that every doctor's visit you make, every religious ceremony you might attend, everyone whose home you might go to is now recorded, it's going to lead to distrust rather than trust, which is what, a system like this would be trying to build, a public health response would be trying to build. And we're also concerned about the disparate impact on communities of color and immigrants. And, the effect of a surveillance tracking approach could really push communities into the shadows. And that's in fact antithetical to what we are trying to accomplish with the public health response, which is make sure that everyone has access to testing, everyone has access to treatment, because the response is only as good as everyone in society's access to it. So pushing communities into the shadows that have very strong reasons to mistrust surveillance and law enforcement and law enforcement's access to surveillance tools, we think that's counterproductive to public health and a violation of civil liberties. So we've really, been very skeptical of proposals that require sort of mandatory tracking or mandatory app use. And again, there have got to be certain foolproof privacy protections, including not, collecting more data than absolutely necessary and not retaining more data than absolutely necessary. And then the third topic I want to touch on briefly is the equity and racial justice issues that I mentioned. So, I think it's well known at this point that the pandemic has had a disparate impact on people in the United States, and communities of color have had greater rates of infection and have had worse health outcomes. One of the concerns we had, particularly a few months ago when this was being floated more, was the suggestion that there might be the use of immunity passports to restart the economy, that people who've gotten sick could be the first to go out and work on the front lines, do the essential jobs, and so forth. And we opposed that proposal, and we wrote a piece about it. I was one of the authors, from a racial justice and disability rights perspective. And the reason for that is, I think it's obvious, but an immunity passport system means that those who have been infected will get priority access to certain jobs. It may be that employers start to want to ask, if workers have immunity, and we'll prioritize them for hiring, or maybe we'll pay them more, they'll get the higher paying jobs. And given the precarity of the economy right now and how many people are out of work, it's not hard to see where the incentives would line up, that many people would feel that they had no choice but to try to contract COVID-19 because they need a job, or they need a job that will, be secure for them. So again, not that people want to, intentionally spread disease. It's just that we have seen in history with the past yellow fever epidemics, that once immunity becomes a currency, something that you can, use to your advantage, the incentives are there, and they will fall most harshly on the people who are, in the most economically precarious situation. Essential workers who cannot work from home, rather than white collar professional workers who are working from home, disproportionately women, people of color. And those are the very communities that are already bearing the brunt of the COVID-19 pandemic. And from a disability rights perspective as well, it's very concerning if, people are given priority, but those with disabilities will essentially be shut out from certain jobs because, if you have a pre-existing condition that makes it more likely that you'll have a severe COVID-19 case, you really probably can't risk it. Or if you're so desperate to get a job that you do risk it, you are going to likely have a worse outcome. And that's just a burden on people with disabilities. And overall, there were so many civil rights and equity concerns with that proposal that we opposed it. And I think it's notable that an immunity passport system is very different from a vaccination system because, requiring vaccines in certain contexts may be justified, but nobody is being asked to get a disease that is potentially deadly, as opposed to an immunity passport system. And then another equity issue that I'll just end on is the concern with immigrant communities in the United States, which I think is a particular focus we've had during this pandemic, because we know that, immigrant communities are already living in the shadows in many ways. We were very concerned that, they were left out of many COVID-19 relief measures. And, I think it's been obvious from the outset that, again, this pandemic has to be a whole of society response, that it doesn't help anyone if there are large communities of people who cannot access testing or treatment, including because of immigration status. It doesn't help any of us if there's unchecked spread in certain communities, with our neighbors who we see and live among because of immigration status. And, at the very outset of the pandemic, I think human rights and public health experts were all saying consistently that this is a time where we've really got to put aside any idea of, citizens are entitled to certain government assistance, non-citizens do not, certain programs that make these distinctions based on immigration status. We absolutely have to make sure that COVID-19 care, testing and treatment, and eventually a vaccination is available to all regardless of status, because it is both the right thing to do from a civil rights perspective, but also the only way to make sure that our public health response will be effective. So I will leave it there, and I think we'll have questions now.
Thank you so much. Oh, I'm still videoed out. Thank you so much. That was really terrific. And we're going to open it up for questions. If you have a question, why don't you just type RTS, request to speak, in the chat box, and I will call on you. Do not be shy. We'll start with Brooke Baker.
I hope I'm not becoming famous for asking questions first. There's a risk, but so, one of the proposals that you didn't talk about in terms of the last issue you raised is the access to the medical technologies, both the testing and therapeutics and vaccines. And we know that there's been an allocation framework proposed both at the NIH level and kind of federal level, but then various academic inputs and alternative points of view. And one of the key issues being floated is preferential access for the communities adversely impacted, Black and brown communities, in particular Indigenous communities as well. And I wonder whether ACLU, whether you put any position in on this and whether you've had inputs and what you think some of the relevant issues are.
It's a great question. I'm glad you asked it because we are actively discussing this issue right now in anticipation, hopefully, of a vaccine in the coming months that will start to be rolled out, even if it's not widely available. We are, we're considering the proposals that have been put out that you referred to, which have proposed an allocation and prioritization framework. Equity is a big part of one of the factors we're considering. So as you highlighted, which are the communities hardest hit? I think another way to look at that question that isn't, that gets at the same thing is, which are the priority groups that, we think from a civil liberties or civil rights perspective also need to be prioritized. And, one concern we've had throughout, which I didn't talk about, is people in detention, jails, prisons, and immigration detention. And a good chunk of our work has been trying to get people released. Just making the argument that these are tinder boxes, they spread COVID-19 rapidly, both the staff and the community coming and going. And so given our work and our priority on that, I think that, we also are thinking through how to prioritize either, vaccination for people in facilities because they have no choice, obviously them being given the option because they, are living in conditions that don't allow for distancing and have very little access to PPE or, other sanitary supplies, and so are therefore at very high risk. How do we prioritize the staff who work in those facilities? Would that actually be a very effective way to both prevent transmission in facilities, while also prioritizing a vulnerable group? We're also thinking very carefully of congregate care facilities because that has real implications for people with disabilities who are living in those facilities. And we, I think, sadly saw a lot of tragic outcomes, not just in the United States, involving nursing homes and care facilities. So I think we are weighing these, and again, I think race and income status and all these factors will come in, and people with pre-existing conditions, people with disabilities will come in, but we haven't yet come out with anything. I think it'll probably be closer to when there's a vaccine announcement.
Well, if I could just say briefly, I mean, the access to testing and therapeutics will be very important as well because, the monoclonal antibodies that are promising need to be given early. If people get tested late and have hesitancy to go to health services, their outcomes are going to be worse. So it's really not just vaccines.
Mm-hmm.
Thank you so much. We have a question from Claire Burgestresser.
Yes, hi. I just want to start off by saying thank you so much for this presentation. I've really enjoyed listening to everything you've had to say. And I'll also put a major disclaimer that I'm a 1L, so I apologize in advance if this is a basic question, but I have a huge interest in disability rights, so I was really excited to hear you talk about it. And specifically the immunity passes, as well as you were just talking about like spaces where folks with disabilities are in groups by need. So from your experience, what are some of the top challenges, are those the top challenges you've seen in defending the rights of people with disabilities amidst COVID? And what kind of, in the most broadest strokes of the pen, what kind of argument structures have you been using to try to protect those rights in this unique time?
That is a great question. So those two issues are definitely two of the big ones, right? Which is, immunity passports and the effect that would have on people with disabilities, and the rights of people in congregate care settings, and what obligations the state has to make sure that, they are given adequate PPE, that they are being that their homes are being maintained in a safe way, and that, protecting people living in congregate care settings is not an afterthought. There are a few other issues that have come up. So, for example, we thankfully didn't really hit this point in the United States, but it could still happen, where we have to get to rationing of ICU spaces, rationing of ventilators. And there is a big concern, from a disability rights, disability justice perspective, if, the criteria that are used devalue the lives of people with disabilities, just systematically, determine that that their lives are of less worth. And I think that's a real concern in the disability rights community. And, there's a history, I think, of, feeling that the medical establishment, has not been good on this issue. So that was something that we were monitoring very closely. And again, we didn't, thankfully, for so many reasons, get to that point where we were hearing, stories of people being turned away from ventilators simply because of a lack. And then another issue that's come up, which is very recent, which might be of interest to you, is the rights of students with disabilities who are now being denied an education, in effect, because they're unable to learn remotely. And we know that, this is not just true for kids with disabilities. There's many kids who don't have a home environment that's conducive to learning. And it's just a really sad situation that we're now looking at, potentially, 6 months to maybe coming close to a year, where many kids will not have had any meaningful in-person instruction. And for a lot of kids with disabilities, that's going to have, real consequences, again, especially if they're unable to get a proper education at home. So that's another thing that I think we'll be watching, because states do have an obligation, to provide public education for kids with disabilities that meets certain standards. It's set out in various legal frameworks and laws. And I think up until now, everyone has been so focused on dealing with community spread, trying to protect students and teachers. I don't know that anyone thought at the beginning that school closings would go on for this long. So this is really a problem that is just going to increase with time, because it's one thing to be out of school for a month. It's not great, but it doesn't necessarily have long-term consequences on your learning. And but if you're talking about 6 months to a year out of school, that's going to have real consequences.
Thank you so much. Martha.
Thank you. Thank you so much for coming to speak with us. I was wondering, specifically when you're talking about like apps and your concerns about surveillance, that made me very curious, because our university has an app that they're having everyone use. And I think there obviously is like a distinction between a private institution such as Northeastern and like government agency, although we do have, like, for instance, our own police force. But I'm curious, when you think about this issue of having these apps and that type of surveillance, what kind of concerns might extend to like a private institution or company requiring those?
Yeah, certainly it's a different context when it's a private institution rather than the government mandating that you use an app. But I do think that the concerns we have apply, and there are a few of them. One is, now, depending on the app you're using, in theory, if it's not super privacy protective, either this private company or your university has potential access to your movements as students, right? All of your movements, all of your contacts, who you see, who you're in close proximity with, where you spend time, how much time you spend there. And that's a privacy harm in itself. Obviously, university students are entitled to, live their lives free from that kind of overbearing tracking and surveillance. So, I would want to know, is this app really collecting more information than it needs? How much information is the university keeping on you? Second, I'd be concerned about other uses of this information. So I mentioned that we have a history in surveillance of things being adopted for one purpose and then expanding. It is very difficult once information exists to push back against that use. So let's say, a university is collecting certain data to try to contact trace quickly. But then it turns out some incident happens, and all of a sudden law enforcement wants access to that data. And even though the university said, no, we're not tracking and surveilling people for law enforcement purposes or for investigations. But now that this information exists, it becomes very difficult to say, well, we're not going to turn it over to you. You need to have airtight laws. In many cases, you need to have airtight policies. And I don't think that many places have adopted these apps, with those airtight laws and policies in place. So, you could end up in a situation where you normalize a new surveillance state where this information can be used from all kinds of things, from civil investigations, internal university investigations, law enforcement, immigration enforcement, far beyond the initial use. So that's why I think, it's really important. One, what's the data being collected? Is it being deleted as soon as the purpose is done, right? You don't really need location or contact tracing information for people beyond a certain number of days when you know, the risk period for that contact having led to COVID is over. But a lot of these ops are not good, or you know, a lot of these companies are not good about purging the data. Of course, there's commercial interests involved in that as well. So those are the questions I'd ask, you know, if you were a student thinking about what's being done on your campus.
Thank you.
Wendy, I don't know if, yeah, I think you were on mute.
Oh, I'm so sorry. Finor, I am hoping I'm pronouncing your name correctly. And everybody,
Sorry.
please, I'm just going to say others, I hope others have questions and put RTS in the chat.
Okay. Yeah, no, you said my name right. Hi, I just want to say thank you for the presentation, and also sorry for any background noise. My question was about how you talked about having testing access was good, you know, both for public health and for individuals on an access standpoint. First of all, I feel like that's like not something that's like being advertised enough when they talk about testing access. I feel like that would change public opinion a lot, but I was wondering if there were any other sort of initiatives that are going on that you think meet this like double goal, or that you think ways to alter things that are happening right now to kind of, you know, fulfill more needs at the same time.
Mm-hmm. That's a good question. You know, in some ways, like I said at the outset, I think that rights respecting public health responses go hand in hand and are better because they engender trust. I think, unfortunately, what we're seeing a lot of in the world right now is a lack of trust in public health authorities, or there's a variety of reasons that we're not seeing a lot of compliance, but there are certain things that public health officials or government officials can do to build trust that make the public health response more effective. And so one thing I would say in response to your question is also respecting privacy, right? So, you know, when you do contact tracing, for example, making sure that the names of people don't get out, they're not widely shared, that you, you know, assure people and can back up the assurance that the information they tell a contact tracer about who they've been in touch with, you know, very sensitive information for many people, that will be kept safe and secure. That's just an example of respecting people's rights, but also having a more effective public health response, because it's not going to help anyone if it comes out that, you know, X public health department shares all this COVID-19 information with the police department, and now, you know, half the community is afraid to tell contact tracers anything. And we've seen, I think, with some subsets in some communities that don't have that trust are not cooperating with contact tracers. And that doesn't really help the public health response. So I'd say that's another example where they go hand in hand. They advance both goals.
Thank you.
Thanks. Simone?
Hi, good afternoon. My name is Simone Yap, and I am a second-year law student at Northeastern University School of Law. I wanted to thank you so much for all of the knowledge and insight that you shared during this time. I really want to go back to what you were just addressing, especially highlighting trust. So everything surrounded COVID and civil rights, and thinking about various communities such as Black communities, and also thinking about Puerto Rican communities specifically, and how essentially we have been used as, you know, test dummies and guinea pigs for various vaccines without our consent, ranging from Henrietta Lacks to the Tuskegee experiment to birth control injections. And so comparing all of that now, especially with the technological front, so we see that on Android phones and iPhones that they're asking for consent to contact tracing, while still not providing as much knowledge towards that. So with all of this request for information, how do you think that, as within the legal field and the scientific field, that more trust can be established, and to further develop transparency surrounding everything that's going on? Because right now, I think in addition to lack of trust, we don't have transparency as to, okay, where's our data going? What is it being used for? What will the results be of this? And will we actually be a beneficiary of it, or will it be hoarded towards the top 1%?
It's a great question. And, you know, I think your point on the lack of trust is one that we think about a lot, and especially with surveillance, because I think communities of color and immigrant communities especially have been used as guinea pigs for a lot of new surveillance technology. It's been rolled out in those communities. They've been subjected to the privacy violations first. And so there's a history of that. And I think that's one of the reasons we were very concerned that if a state or a governmental entity is going to adopt a technology first approach, even leaving aside just the privacy considerations, it might backfire, because are you really going to have a lot of adoption? Are people going to trust this app? Are they going to trust the information that's being taken from them will be kept secure? If you don't have a lot of adoption in the very communities that are being hardest hit by the pandemic, then what is the point of doing it, right? Then you're just gratuitously collecting data. But if in fact the people who are being affected by COVID-19, the people who are maybe essential workers, are the ones who don't trust it and are not adopting it, again, you've got a failure of efficacy with with a lot of privacy downsides. I think my answer is a little bit similar to what I said to Fiona, which is, I think you build trust by having legal safeguards and frameworks that are transparent and well known to everyone and that you abide by. When it comes to privacy apps, for example, we've said that any privacy respecting app would be auditable, meaning that someone could, periodically, an independent entity could come in and say, okay, you said you weren't going to retain this data. We get to check. You said you were going to delete data after a short period of time. We get to check. We need to make sure it has to be open and accountable, that the assurances that are being made are actually being complied with, particularly for vulnerable communities that really have reason to fear how their data will be used. And I think that is one way to build trust. I genuinely think that respecting civil liberties and being transparent about what you're doing goes a long way to building that kind of trust that can make public health easier to manage.
Thank you.
Do we have any other questions? If not, I will ask, but I really want to hear from everybody else, and especially the students who are here. So I will ask one while we're waiting, and thank you so much again. So I'm going to be sort of overstated a little bit, but I think one of the things, when you and I started talking, and we were talking in the early spring, we were obviously very worried about all the issues you were talking about. But one of the things I think that has happened in the last few months is we've kind of gone from perhaps the concern of over-enforcement to under-enforcement of public health. And so instead of, as you said, we're not seeing widespread mandatory quarantines. There are a lot of orders that are out there, but to be blunt, most of them are not actually being enforced. Instead, I would argue that what we're experiencing is a different kind of loss of liberty, right? We're not experiencing the loss of liberty because the government is I'm not in my house today because the governor is keeping me in my house. I'm in my house today in part because the governor's not, enforcing XYZ. And I wonder how you and the ACLU, because we haven't talked much in the last few months, have been thinking, do you sort of broadly agree with that diagnosis? And then if so, how is it influencing your organization's conception and how you think about liberty and the relationship in some sense between our constitutionally protected fundamental rights and perhaps, right, the other things that are necessary to actually provide and safeguard liberty?
It's a really tough question. In fact, I think your question gets at the heart of, balancing civil liberties or more traditional civil liberties and traditional civil rights concerns with, a more affirmative conception of human rights or economic justice, because I think it also goes to not just the fact that, you're unwillingly at home right now because it's not safe to do the things you would normally do, but also, how many people are unwillingly at home and out of work and suffering economically, and what are the obligations of the government in a circumstance like that? And we do weigh these things very difficult. They're very difficult because, on the one hand, it's clear, right, that in some ways, the problem isn't over enforcement. The things that we were worried about at the beginning of the pandemic haven't necessarily come to pass. And I'll just say, you know, at the beginning of the pandemic, we were very worried of criminalization of people for lack of compliance. And, you know, for a variety of reasons, we don't think that, you know, public health measures should be enforced with criminal penalties. You know, it's a harsh measure. We have a history of unequal enforcement and biased and racist criminal laws, you know, being enforced against communities of color. And it just doesn't make sense to put people in jails and prisons during a pandemic. It's counterproductive. That said, there are other ways of encouraging compliance, of pushing compliance, of, you know, sort of a whole of society response that we just haven't seen. And it does also have a disproportionate impact on certain communities. So, you know, I know that, you know, ACLU affiliates in some states where they didn't even really have even sort of the early stage bare minimum, like mask mandates or, you know, restrictions on certain businesses. And there was widespread community spread that was really affecting the Black community in particular, Native communities, Native American communities in particular. And, you know, thinking through how do we think about the state failure to act when it has such a disproportionate impact on certain communities from a civil rights, human rights perspective. And I don't think that there are easy answers, especially, you know, when we're talking about, you know, what are the solutions, you know, short of, you know, the government should be spending more money on a coordinated public health response that, you know, makes sure that every community has what it needs, including money to stay home so that, you know, people do not suffer economically if and when it is necessary to stay home. So I think there's a lot of sort of pain points of where you could say, okay, here's where the response has just failed to effectively control COVID-19. And here are where, you know, we as the ACLU might have something to say. I mean, I think that education is going to be one that will increasingly become an issue because the failure to get the pandemic under control means that we're in a place where it's, you know, schools are not open in many places of the country, public schools. And that is a civil rights concern. You know, who are the students who will be most deeply affected by the failure to get the pandemic under control and the failure to provide them with an education for upwards of how many months?
Yeah, thank you so much. I have to say, I wonder about how we talk about liberty, you know, when liberty was liberate Michigan, right? We need to think about that. John.
That's actually exactly what I was going to just sort of ask about, just sort of more of an ideological question than a legal question, but how the rhetoric of civil liberties in the, you know, sort of just generally, I guess what you think about the way the rhetoric of civil liberties has been sort of appropriated for, you know, for saying, you know, like, you know, that it's, you know, violating my freedom to wear a mask or liberate Michigan, exactly. And, you know, sort of this double edge of you know, and the care you've got to take with sort of deploying this rhetoric and how it can be used to actually, you know, essentially subvert, right? Because that's why Wendy is in her home, right? Is in part because of the way the rhetoric of civil liberties has been subverted in a manner that actually is, as a practical matter, not as a legal matter, sort of constraining people's liberties. I don't know where that leaves us, but I'm just curious where your thoughts might be.
I think it's a real challenge. It's a challenge we face in a variety of issues, but particularly in this one where you're right that the rhetoric, you know, has been co-opted or subverted in many cases to essentially claim a right to harm other people, you know, where you know that your actions will be harming other people. And you know, what does that mean about a conception of liberty? I think it is our job as a civil liberties organization not to give into that co-optation, because there are real civil liberties concerns at stake in a pandemic. And so we can say that, you know, while on the one hand, you know, liberty or freedom in, you know, a society like the United States does not mean freedom to impose, you know, potentially deadly harms on third people, and that there are certain, you know, all of our fundamental rights, you know, there are limits and constraints on, you know, just pure, you know, libertarianism and pure freedom, and you know, in its most unrestrained sense that we have, you know, in order to have a functioning society. But I don't, you know, I don't want us to see that rhetoric and think that then that means there are no civil liberties and civil rights concerns with the government on both sides, both failure to act, failure to protect people, but also, you know, over harsh, surveillance or law enforcement approaches. So I think for us, the challenge is finding that balance, how to speak about this without sounding like we do not care about other people, because that is absolutely not the case. Civil liberties and civil rights perspective, has to say, first of all, we prioritize people's life and health and their ability to live and be healthy. That's a key part of it.
Any other questions? Especially from the students, but anyone. You've raised so many really important and complicated issues, right? There's not necessarily clear answers to these, but your framework was really exceptionally helpful and clear. Summer.
Hi, just following up on that discussion about liberties and, liberties not being completely boundless. I was wondering if you could discuss a little bit more freedom of religion and freedom to exercise your religion. I guess I'm kind of thinking, if we find ourselves with a new president who is a little bit more interested in these lockdowns and maybe not letting people practice their religion in large indoor spaces, how you see that playing out in litigation or policy responses?
That is a good question. First, I would say I think the religion example where you raised, where I thought you were going with it was claims of religious exemptions from generally applicable laws like discrimination laws, anti-discrimination laws, and that I think actually strikes me as an apt analogy to John's question about, at what point does your liberty impose harms on third parties, right? At what point, if your claim of religious liberty is going to, impose harms on people because they will be discriminated against, that question I think we see in this COVID-19 pandemic response. I'll just say that at the ACLU, we both have, an LGBT rights project, a racial justice project, a women's rights project. We have many equality focused projects, and we also have a program on freedom of religion and belief. So it is one of those issues that we actively think about, and there are many, competing interests and issues at play, and the right to worship, the right to practice your religion is a fundamental right, and it's one that we take seriously. But we also, strongly support anti-discrimination laws to protect people. And, I think one of the biggest challenges we're going to see coming up in the next few years is preserving those anti-discrimination protections. I think that's going to be something we see more of.
Can I ask to push you a little bit more on that? I'm curious, not the ACLU's position then on the issue that was supposedly before the court this week. Is it this week? I have no sense of time and space anymore. In the Fulton case, I gather they didn't really focus on it, but the question of overruling Smith.
We were actually counsel of record in that case as interveners. So, supporting the city of Philadelphia, and for the rest of you, the case is Fulton v. City of Philadelphia, and it's about whether the city of Philadelphia can contract with private entities to run its foster care system, where the private groups help, screen and place foster children with foster parents. And Philadelphia doesn't want to contract with a religious entity that would not screen and accept same-sex married couples to be foster parents. And so we were on the side of the city arguing that, the city absolutely can enforce its anti-discrimination laws and has an interest in doing so, and in not contracting with entities that will not abide by its requirement that it not discriminate based on LGBT status.
Thank you. And obviously, just for the students on it, it has potentially broader implications beyond the already very important implications for LGBTQ rights, and relates to the pandemic because there have been so many claims for sort of religious opt-outs from some of the health laws, at least theoretically. Any final questions? I think we have room for one or two more. If not, I think probably everybody wants to quickly go back to their doom scrolling and see, or whatever it is called these days. So please everyone join me. Thank you so much. This was such a wonderful talk and great conversation. And thank you for the work you're doing and for joining us by Zoom. I hope that someday we will be able to have you in person. And thank you so much. So everybody join me. I really appreciate this.
Thank you for having me.